Kesavanand Bharati versus State of Kerala, India's most important Supreme Court judgment. The Supreme Court of India is often regarded as a kind of a messiah for the Indian people. And why not? If you look at the sheer kind of judgments that the Supreme Court has passed, for example, declaring the right to privacy as an implied fundamental right under Article 21. This was done through the Puttaswamy judgment. Another example, the Supreme Court upheld the right to a dignified life by ensuring and recognizing passive euthanasia and a living will through the common cause judgment. The Supreme Court not only enforced and upheld the rights of the people, the Supreme Court also gave some very positive judgments. For example, in the judgment of Lily Thomas, the Supreme Court clearly said that convicted MPs and MLAs would be prohibited from contesting elections. And this is not all. Sometimes the Supreme Court protected itself by invalidating the National Judicial Appointments Commission Act as it violated the independence of judiciary and would open judiciary to severe governmental intervention. And the list goes on and on. In fact, the Supreme Court of India is very much a part of India's policy as much as the government is. Then the question becomes, how does the Supreme Court become such an involved, such a fearless agency going toe to toe with the governments of all times and ages? What is the root of all the judgments that I just mentioned before you? The Indian Supreme Court is widely regarded as one of the most powerful and the most efficient Supreme Courts of the world. So the question then becomes, what makes the Supreme Court what it is? And the answer to this question lies in the formative years of India's independence. Deeply inspired by the Russian model of socialism, and socialism basically means the government control of resources for equal distribution of resources. Deeply inspired by the Russian model of socialism, India embraced it with open arms, which means India was ready to control resources for equal distribution of the same resources. Now, India, as it embraced socialism, also needed to understand certain critical realities. The first was, majority of India was and still is an agrarian economy. And the most important asset in an agrarian economy happens to be land. Now, if socialism has to be applied to this, it would mean land had to be redistributed for real agrarian reform. And the problem was, very few people owned most of the private land in the country, leaving most other people either landless farmers or landless laborers. And this created massive land inequality, which means India had to redistribute land. And it often was not that simple. You see, land is a state subject under Entry 6 of Schedule 7. This means that the state governments have the authority to make respective land reform acts. So if land had to be reformed, it would have to be reformed at the level of the states. Thankfully, it was very easy to undertake such land reform acts. This was because in the initial years of India's independence, most of the state governments belonged to the same political party at the center, which was the Congress, which basically means the Congress party at the center essentially asked the states, which also had Congress parties, as governments to enact various land reform acts which would impose a limit on the amount of land a landowner could own. a kind of a land ceiling, if you may. Now, obviously, landowners were losing land and they were visibly very upset, and they decided to challenge these very laws. Let's understand how. If the landowners had to challenge these laws, they had to challenge these laws on the basis of something that was being violated. What was being violated? The Constitution of India identifies three core fundamental rights which were in question. The first is Article 31, the right to property, which guaranteed the people of India to own property. Now, when the state governments were making laws to take the same property away, the landowners were alleging that their right to property seemed to be in danger. The next one was Article 14, which states the right to equality. Now, right to equality clearly states no two people can be treated differently before the same law. Now, a landowner who has land was treated differently before the same land reform law, where the landowner had to give up land. So the landowner was being treated not in an equal manner. And lastly, Article 19. This meant two things. One, Article 19 assured a person could execute any profession of the person's choice. By taking away land from the landowners, it was alleged that the government was taking away the profession of the landowners as being landowners. And second, land was also considered as a medium of one's own expression, which means those land reform laws were violating, allegedly, the fundamental rights. Which now brings us to who says so? The weapons. Now, Article 13, Clause 2 clearly says that no law can violate fundamental rights. So the landowners thought that if no law can violate fundamental rights, any land reform law that violates such a fundamental right would essentially mean a violation of 13 Clause 2. Articles 32 and 226 empower the people of the country to directly go to the Supreme Court and the High Court, respectively, whenever the fundamental rights of the people seem to be violated, and therefore cases could be filed in the Supreme Court and the High Courts of the states where the Land Reform Acts were enacted. And what were they challenging? They were challenging the Land Reform Acts. So, the landowners were challenging Land Reform Acts on the grounds that these Land Reform Acts were violating their fundamental rights, which was prohibited under Article 13, Clause 2, and the three fundamental rights in question were 31, 14, and 19. Now, several such cases were filed in the respective high courts of the country. The government had to respond. And the government's response was quite short, was nothing short of interesting. So, what does the government do? The government, very, very simply, under Article 368, which allows for the amendment of the Constitution, enacts the first Constitutional Amendment Act of 1951, which added two new provisions to the Constitution. The first provision was that no fundamental right is violated if the government acquires land. This was a direct counterattack to what the landowners were saying. Second, under Article 31B, which was also added later, the government said that we are going to create something called the Ninth Schedule, and anything inside the Ninth Schedule could not be challenged in a court of law. And the government, in the same amendment itself, added the reform laws of Bihar, Bombay, Madhya Pradesh, Uttar Pradesh, Hyderabad to the same ninth schedule, which means each of these states which had enacted the land reform laws were now placed in the ninth schedule, and no landowner could challenge them because they were in the ninth schedule and were immune from judicial review. Now, the First Amendment Act was a massive blow by the government to these multiple cases of landowners filing across various high courts. And this is where the battle begins. The first milestone happens to be Shankari Prasad versus Union of India in 1951, in the same year as the Constitutional Amendment Act was enacted. Now, one such landowner whose land was taken away was Shankari Prasad, and he was losing a lot of land due to these land reform acts. Now, he could not challenge these acts because the act of his state was placed under the ninth schedule. So he thought of something very smart. He said, fair enough, I can't challenge my state land reform act because it is in the ninth schedule. But what if I could challenge the very way through these acts were placed in the ninth schedule? So he challenged the first Constitutional Amendment Act of 1951. The very first constitutional amendment of our country was challenged within the first year itself. And that's essentially the background to Shankari Prasad. Now, the Supreme Court essentially looked at a very interesting line of thought. Let's first understand what did the core arguments comprise of. So if you were Shankari Prasad and you were arguing this in the Supreme Court, this is what you would have said. You would have said, Article 13, Clause 2 clearly says no law can violate a fundamental right. And here, the Parliament has made a chunk of land laws which take my land away and stop me from coming to court, which is also a violation of fundamental rights. So, how did you stop me from coming to court? By placing them in the ninth schedule. And this is why I, Shankari Prasad, am challenging the first Constitutional Amendment Act of 1951. The government, now if you were the government, you would have said, hold on a second, Article 368 clearly allows me to change the constitution, and I can change anything in the constitution, including fundamental rights. So if I create the ninth schedule and if I add something to the constitution as a part of the ninth schedule, Article 368 allows me to do so. So you may not have a ground. Now let's see what the Supreme Court said. The Supreme Court, being the interpreter of the Constitution, gave a very interesting interpretation of the word law mentioned in 13 Clause 2. Now you would remember Article 13 Clause 2 clearly says no law can violate a fundamental right. Now the Supreme Court said, no doubt, a law cannot violate a fundamental right. But please understand what we're going to say next. The key highlights were the Supreme Court said, fair enough, no law can violate fundamental rights. But a constitutional amendment does not even come under the ambit of the word law. So the word law, according to the Supreme Court, does not include constitutional amendments as far as Article 13, Clause 2 is concerned. To justify this further, the Supreme Court said there are two kinds of lawmaking powers. One, a constituent power, the power to make constitutional amendments under Article 368, and the Parliament seems to have this power. An ordinary power is the power to make any other law, regulation, or rules outside Article 368. And the Supreme Court says that the word law here refers to laws which are made in the exercise of ordinary power and therefore do not include the constitutional amendments. Now, this, as surprising as it was the first milestone called Shankari Prasad versus Union of India, and the outcome was very clear. The government had won this case. The first constitutional amendment stood as intact as it were. The law, as in context of Article 13 Clause 2, does not mean constitutional amendments. The first constitutional amendment, therefore, is perfectly legal, and the Parliament has the constituent power to amend the Constitution. And if the Parliament wants, they can make any changes to the Constitution, including fundamental rights. For 13 years, since 1951, there was absolutely no progress on this matter, and no one really bothered about the issue. But the government enacted the 17th Constitutional Amendment Act of 1964, and this act was more of a bittersweet kind of an experience. The sweet experience was it added a clause to Article 31A, and it said that when the government was taking land away from the landowners, the government would try its level best to give the landowners compensation based on the market demand or the market based rates. The not so sweet, the bitter part of the 17th Amendment was that the government added more than 40 different land reform laws of different states to the ninth schedule. And as we know, anything added to the ninth schedule as of this could not be looked into by the courts of law. And out of these 40 land reform laws were also included laws from Rajasthan and Punjab, and these two would play a significant role in the times to come. Like Shankari Prasad, there was another person called Sajjan Singh. Sajjan Singh, who was a landowner of Rajasthan, and therefore the next case comes to light. Sajjan Singh versus the state of Rajasthan in 1964. As we said, Sajjan Singh was a landowner of Rajasthan who was losing a lot of land because of the Rajasthan Land Reform Act, an act which was later added to the ninth schedule because of the 17th Amendment Act of 1964. Sajjan Singh did exactly what Shankari Prasad had done. He couldn't challenge the act per se, but he could challenge how the act was added to the ninth schedule in the first place. So he challenged the enabling law. He challenged the 17th Constitutional Amendment Act of 1964 on the same grounds as Shankari Prasad. Sajjan Singh was a lot like Shankari Prasad, and therefore the verdict was also quite similar to that of Shankari Prasad. And the outcome of this was exactly the same as Shankari Prasad's case. The government here also won. The government won, and it said that the 17th Amendment is perfectly legal. The law does not mean constitutional amendments. Not only is the 17th Amendment legal, the First Amendment is also legal. The Parliament has the constituent power to amend the Constitution, and the Parliament can make any changes to the Constitution, including fundamental rights. So, as of now, things remain unchanged. But not for long, because through the same 17th Constitutional Amendment Act, land laws of Punjab were also added, and that's what brings us to the second strike, Golaknath versus State of Punjab. Now, Golaknath was a very prosperous landowner in Punjab. He was said to have more than 500 acres of land, and because of the Punjab Land Reform Act, he would lose about 470 acres out of the 500 acres and would only be left with 30 acres of land. And this Land Reform Act, much like earlier before, was also placed in the ninth schedule. Golaknath did the exact same thing as Shankari Prasad and Sajjan Singh did. He challenged the 17th Amendment Act of 1964. He said, "Fair enough. I can't challenge the act because it's in the ninth schedule, but I can challenge how the act was put in the ninth schedule." And the verdict was a complete reversal of all prior judgments. The Supreme Court, taking a complete U turn to its previous judgments, said a few things that literally sent shockwaves of good and bad across the country. The Supreme Court said, as of Golaknath versus State of Punjab in 1967, constitutional amendments are very much law under Article 13, Clause 2. Second, no one can amend fundamental rights because fundamental rights derive their origin from the constituent power. And as of Golaknath, the Supreme Court said the only people who have constituent power was the Constituent Assembly. So if you wanted to change fundamental rights, you'd have to reconvene the Constituent Assembly, which obviously was impractical and very unreasonable. So that essentially meant no one could amend fundamental rights. And the Supreme Court went a step further. The Supreme Court said the Parliament seems to claim that they have the power to amend the Constitution, but they don't. The Parliament seems to often quote Article 368. But Article 368 simply says the procedure to change the Constitution. It does not even mention the word power. The Parliament derives these powers, assumes these powers because of the residuary principle. The residuary principle is very simple. If it is not mentioned who has the power to make a law on something, then the power rests with the center, which is the Parliament. So the Parliament put two and two together and assumed that they had the power to change the constitution, which, as of Golaknath, they didn't. And this was very, very interesting because this now essentially put the Supreme Court in the direct line of sight with the government. Now, this led to an eye to eye battle between the Supreme Court and the government because this judgment essentially kept the government on a tight leash. It restricted the powers of the government to make any changes that it would feel like. But as we know, the government would have not stopped. And that led to a never ending battle before the final round. The government immediately retaliated. The government enacted the Bank Nationalization Act of 1969, because of which 14 banks were made to come under compulsory government control. Not only this, through a very controversial presidential order in 1970, the government abolished the Privy Purses. The Privy Purses is basically a sum of payment that was promised to Indian princesses at the time of independence. Now, the Supreme Court was not going to stand back. The Supreme Court, in its judgment of R.C. Cooper versus Union of India, struck down the Nationalization Act. It said that the criteria for compensation which is being used is wrong. The Supreme Court, however, tried to balance things by saying that the Parliament does have the right to nationalize banks, just not the way they did in 1969. The Supreme Court, in another case called Madhavrao Scindia versus Union of India in 1971, also struck down the very presidential order which abolished Privy Purses, which basically abolished the payments that were paid to Indian princes. The government was flabbergasted, and the government was not ready to give up. The government immediately, within 1 year, provided for more than three constitutional amendments. The primary ones are the 24th Amendment of 1971. This amendment directly countered what the Golaknath case had said. The Golaknath case said that the law includes a constitutional amendment. The government added 13 clause 4 and said a law doesn't. It directly conflicted with what the Golaknath judgment was. Not only this, the government also added a new clause called Article 386, Clause 3, where it said that Article 13 would not apply to 368, which basically meant that the Parliament could make any law even if it violates fundamental rights. And because Golaknath constantly stressed on the word procedure, the government said, you know what, let me change it. And they changed the word procedure to power in Article 368, which meant that Article 368 now read that the government has the power to change the constitution. Not only this, the government also enacted the 25th Constitutional Amendment of 1971 and added Article 31C. Article 31C had two parts. The first part was that the government placed two directive principles, 39B and 39C, as superior to three fundamental rights, Articles 14, 19, and 31. Now, 39B says equal distribution of wealth, and 39C says equal distribution of resources. So, what this article really meant was that if the government did anything to implement an equal distribution of wealth and resources, to implement 39B and 39C, and your only objections to that was 14, 19, and 31, equality, expression, and property, then whatever the government did would be more important than a fundamental right violation. If you notice this carefully, nationalization of banks was to provide for equal distribution of wealth so that everybody has equal access to resources. So, this was the government's slimy way of poking holes to the nationalization judgment. They, anyways, had the power to nationalize banks. And the second part was, if such a thing happens, then such an action of the government, whether it is through a law or a scheme or an order, would not be judicially reviewable, which means the government placed heavier restrictions on the judiciary not being able to intervene. And very, very bravely, the government also enacted the 26th Constitutional Amendment Act of 1971, where it directly nullified the judgment of the Supreme Court, which had struck down the abolition of privy purses. So this was basically the government did X, the Supreme Court did Y, and then the government did Z. And this kind of a battle continued until the final round. And the final round was what would change the course of history of this country, because this seemingly never ending battle between the government and the judiciary would have continued if not for what now happens. The Supreme Court was ready, but the government enacted the 29th Constitutional Amendment Act of 1971, yet another amendment, the fourth one of the same year, and added the Kerala Land Reform Act to the ninth schedule. Now, because of this, Keshav Nanda Bharti, a saint of the Edgar Mutt of Kasargod in Kerala's land was to be taken away by the government. Now, this was essentially the same circumstances, and Keshav Nanda Bharti was ready to challenge the 29th Act. Now, obviously, the same principle, the Keshav Nanda Bharti case, in which Keshav Nanda Bharti could not challenged the Kerala Land Reform Act because it was in the ninth schedule, it could definitely challenge the way the Kerala Land Reform Act was placed in the ninth schedule. A lot of people don't know this, but an interesting fact that Keshananda Bharti was not alone. He was joined in by a lot of other co-petitioners. They included former princes because they were upset because of the privy purses. They included owners of sugar mills and mining companies because the government would now do anything to equally distribute wealth and resources, and of course, the other landowners. So, a total of 6 people, including Keshananda Bharti, filed the Keshananda Bharti case with Keshananda Bharti as the lead petitioner in 1973, within 2 years of the amendment of 1971. And the judgment was as follows. The Keshananda Bharti judgment was essentially a balancing act. The Supreme Court has had enough, and the Supreme Court wanted to make peace once and for all. And for the first time, the largest ever bench of 13 judges of the Supreme Court sat together and delivered the most historic judgment that would change the very fabric of India. And interestingly, this is how it happened. The Supreme Court, in Keshananda Bharti's case, essentially said the following. It said that the Parliament can amend anything in the Constitution if it does not violate the principles of basic structure. It also partially struck down Article 31C, which prohibited judicial review of actions where the DPSPs were superior than fundamental rights. And the judgment also said it was prospective in nature, which meant all laws which were added to the ninth schedule till 1973 shall remain to be immune from judicial review. Now, interestingly, basic structure is not a set of articles, it's a set of principles. And the Supreme Court would now tell you what these principles are. The Keshananda Bharti judgment set a new course in Indian polity. So let's quickly look at the timeline. It started with the First Amendment, where a few laws were placed in the ninth schedule. Shankri Prasad challenged the First Amendment. Then happened the 17th Constitutional Amendment in 1964, where a few more state laws were added to the ninth schedule. Sajjan Singh in 65 and Golaknath in 1967 challenged the very 17th Amendment because of their respective laws which were added to the ninth schedule because of the 17th Amendment. The Golaknath judgment severely upset the government, and the government enacted the 24th, 25th, and the 26th Amendment of 1971 and the 29th Amendment of 1971 enforceable in 1972. Now, the Keshananda Bharti judgment happened in 1973, and the story continues. By no means this was the end, and no doubt the government tried a few more tricks under their sleeve. For example, the 39th and the 42nd Amendment of 1976, where certain restrictions were tried to be placed on the judicial review. And therefore, the Supreme Court intervened again in the Indira Gandhi case and the Minerva Mills case, where the Supreme Court clearly established that judicial review was basic structure and no law could violate fundamental rights. The basic fact of the matter remains that the basic structure is a set of ideals and principles which the Supreme Court enshrines in its judgments over time. So basically, the Parliament cannot amend anything that violates the basic structure of the Constitution, and the Supreme Court tells us what constitutes basic structure and what doesn't. Whether it is secularism or judicial review, whether it's parliamentary democracy or judicial independence, these components of basic structure have been given to us by the Honorable Supreme Court. Sometimes the court rightly allows women to enter temples and as secularism is basic structure. And as you discussed before, sometimes the court rejects NJAC as independence of judiciary is basic structure. Some say that an active court is to compensate for a lackadaisical legislature, and some say Keshavananda Bharati was the starting of an era of judicial supremacy, questioning separation of powers. The fact remains 13 judges, one saint, and land changed the way India now functions, all thanks to this judgment. And everything else that you study in and around you, that you refer to in and around you, owes its origin in one form or another to the Keshav Nanda Bharati judgment of 1973. Thank you for watching. If you like the content, please like, share, and subscribe for more quality content coming your way. Thank you.